G'day, welcome to the first QLS Ethics Centre Facebook live feed. I'm David Bowles, I'm an ethics solicitor with the QLS Ethics Centre. I'm joined today by my colleague Shane Budden. Hey Shane.
Hello everyone, hello David.
Before we start, we would like to acknowledge the First Nations people as the original inhabitants of this land. We were broadcasting this live feed here in Brisbane, traditionally known as the Meanjin and the home of the Jagera and Turrbal people. We equally acknowledge the nations from every corner of Queensland, and we'd like to extend this to all elders, past and present, as well as to the emerging leaders of today. We recognise, respect and celebrate the First Nations youth, the leaders of our future. Today we're going to discuss the federal government's new federal data breach reporting regime, and importantly for the profession, that commences on 22 February. Just as an outset, Facebook Live is a new format for us, so if we have any technical issues, please bear with us. We're hoping to use this as a means of connection with the profession throughout the state, so this is not this is the first of a long series for us, but in case we have any difficulties, the material will be available on the website later. Now, Shane, data breach is obviously not a new thing for law firms. It's been very much in the news for us over the past year. Law firms have always been vulnerable, and the bad guys have really recognised that and have been having a good time with the legal profession. So what's the difference, though? What's coming up on 22 February, and why does the profession need to know about it?
Okay, well, you're quite right, David. In the past, we've dealt with this in a different way, and in fact, we've sort of been able to deal with it in a fairly private way, in that, you know, you've told your clients if there's been a data breach, you've done whatever you could to rectify the damage, but you haven't had to report it anywhere. The big difference here is that if you do suffer a data breach, which is captured by the new legislation or the amendment to the Privacy Act and the new regime, you're going to have to report it at least to the Office of the Information Commissioner and possibly to other people as well. So it's a sort of a situation where you're going to have to dob yourself in, whereas in the past you could probably sort it out with your clients, sort it out with your IT people or whatever you have to do to prevent any further ongoing breach. But you've been able to deal with it in a fairly private way. That's not going to be the case from now on.
Okay. I mean, I will stress that from our perspective, we've always had an obligation as a fiduciary to report the loss of client data to the client and do so as soon as you conceivably can. So that's not changing. But is it just firms with 3 million turnover or more, or the current privacy regulated entities, or is that going to be different as well?
Well, it is going to be different in that I guess the big one for most of our member firms is that if you collect TFNs, the tax file numbers from clients, you're going to be captured by the legislation and the regime, and I think most of us at some point or another have done that. But also we have to anticipate the anti-money laundering provisions are going to come in. Once they come in, pretty much every law firm is going to be captured, and the situation simply is that any prudent practitioner from 22 February is going to assume that they are captured by this regime and to comply with it. There's really no way out, and you can't take any comfort from the fact that you don't have a $3 million turnover. You're going to be caught by some of the other provisions. Best to start preparing now.
Okay, so just to confirm, if you're regulated by the Privacy Act now, you will continue to be regulated by this new element of it. If you collect tax file numbers for any part of the practice, so I'm assuming you don't just need to lose a tax file number. If you've collected it for another purpose, then you're caught by the regime. And then the AML CTF Tranche 2 changes will capture you anyway. So this is the last wake-up call, I take it?
Basically, yeah.
Okay. So one way or another, we're all going to be caught by this. What's exactly been caught? So what sort of data breach activates the reporting obligation, and what does it look like?
Okay, well, this is the big issue for us, in that the data breach legislation, the regime, is drafted quite broadly, and I think quite deliberately so. And it will capture any unauthorised disclosure of information that is likely to cause serious harm. Now, I wouldn't take any comfort from anyone from the use of the words likely to cause serious harm. Everybody by now should be aware that a minimal amount of client data can be used to create a maximal amount of damage. You can get into a position where you can steal someone's identity. If you pick up even a minor amount of data on a client, if you can match up all the details, you can do a hell of a lot of damage there. So I don't think we can take any comfort from the use of the term serious harm. If you lose a USB stick, if you lose your mobile phone, if you leave a file on a bus, the chances are pretty good that you've lost client or given unauthorised access to client data, which is likely to cause serious harm, and you're going to be captured by the regime.
Okay, so we can't hide behind the definition. We must assume that virtually any data loss is going to potentially amount to serious harm, because simply you're not going to know until it all comes out in the wash later. Now, either as we speak, and there's certainly going to be a few people out there that are in this position now, or in a couple of weeks' time when this regime's in place, hypothetically speaking, you wake up and you realise that a USB stick which you quickly downloaded half a client file to is now no longer able to be accounted for. Might be in your kid's school bag, might be on the bus, it might be in the hands of a bad actor somewhere. What do they have to do? Okay,
first things first, you have to very quickly make an assessment as to the nature of the information that's lost and whether or not it is something that's likely to cause serious harm. And as we've covered, it probably is. And you then need to work out the best way of dealing with it. Now, the Act does give you some potential outs, but the big thing is, in most circumstances, you're going to have to draft up a statement that is mandated in the regime as to what has to be included in it. You'll have to send that to your client, and assuming you can identify the clients that have lost the data, and you'll also have to send it to the Office of the Information Commissioner. So that's what I meant at the start of the cast when we said that you're going to have to dob yourself in. You are going to be putting your hand up and to your clients, but also to the Office of the Information Commissioner, saying, look, here's what's happened, here's the stuff we've lost, and here's the situation. And that's important because there are other things that you might have to do if you can't contact your clients, but the Information Commissioner has pretty broad discretion as to what they can direct you to do, and one of the things is they can direct you to disclose it in a more broad sense. So those are your first steps. Work out what you've lost, whether it's likely to be a problem, then you identify the clients, tell them, and you tell the Office of the Information Commissioner.
Okay, so presumably that means that if you haven't done it already, firms have got to get a lot more careful about where large amounts of electronic data are recorded. For example, with the flash drive, which is still the favourite way of losing large amounts of data in one go, if the US information regime is anything to go by, you've unless you know what's on it, then obviously you're going to have to assume that your entire client base is potentially affected, and that would have a catastrophic flow-on effect. So presumably that means for flash drives, you need a register of them, you need to have a list of what's on that material, and obviously keeping old miscellaneous files and bits and pieces recorded on portable devices that don't have to be is no longer a good practice if it ever was.
Yep, and look, you touch on a great point there, David. If you can't identify the exact clients that are on that USB stick, and let's face it, if you're into using that, you may have used it over a period of time, there could be 20 files on there and you can't remember which ones, then you're going to be in a position where you have a disclosure in a broader sense, and the way that the regime mandates it is to put a copy of that statement on your website. So if you can't identify the clients and notify them individually, you're going to be notifying the world that you dumped a bunch of client data. That's not going to put you in a great branding position, and it's one of the things that you would like to avoid. As you say, our practices around USB sticks have to change massively, and look, there are simple things too. Simply branding the USB with your firm details so that, you know, if lost, returned to, might be useful to you. And one of the reasons that it might be useful to you is in relation to what you can do to avoid having to comply with these notification breaches, is that if you can take remedial action within the appropriate amount of time, you may be relieved of the disclosure issues. So, say for example you lose an iPhone and it's got client data on it, and I think any one of us that use a smartphone these days, there's some client data on it somewhere. If you can remotely delete it within a period of time that a reasonable person would think, yeah, well, no one will have cracked the code by then, and you do that before anyone's managed to access that data, you don't have to go through a reporting regime. It's something you really do want to be sure about,
yep,
because of the consequences of getting that wrong. And I think the other thing to bear in mind with that is, okay, that can avoid the need to comply with the regime under the Privacy Act. We would still say at the Ethics Centre that if you've lost client data and you can notify the clients, you have to. So remotely delete your iPhone, problem solved as far as the IC is concerned. But in terms of your fiduciary obligations, I think you still have to notify any client if you've lost their data. Regardless of this, you're still going to have to notify them, but at least you're not having to be telling the world if you can take advantage of the remedial action.
Yes. I mean, obviously, with the limited disclosure of sitting down with the client, explaining exactly what risk that they've been exposed to, you can manage the reputational and brand damage far more easily than a broad spectrum. By the way, your data may have been exposed. We can't tell you what, and we can't tell you who's got it. So, presumably, then, best practice means minimise the amount of electronic data you're moving. It means never move it unencrypted. But even the encryption only buys you time. It doesn't buy you a guarantee that the device won't be tortured and hacked. So, in effect, do we have any recommendations and any further information that people are going to need to get their head around this new change and what they're going to have to do about it?
Yeah, well, look, a couple of things there. One is that in the March edition of Proctor, there's an article I've co-authored with immediate past President Christine Smythe about this, and we go into it in a lot more detail, and there are a lot of things we've come up with that might be able to help you avoid this, because it's one of these situations where there's nothing, no area where prevention is better than cure than in this particular area, because once you go over the edge, you're probably in a world of hurt. You mentioned a register of USBs. Yep, branding those USBs, branding electronic devices, even making the decision as to how you're going to deal with data, whether or not it is worth the USB issue, or whether you take a different approach and give your staff access to your electronic files through a VPN or something like that you consider to be more secure. But there's a range of things in that Proctor article that will be of use, and we go into it in more detail. Obviously, this is a limited format. The things that I do want our members to take out from this: have a look at the legislation. It's not a huge amendment. It does bring this thing within the Privacy Act, and that does mean that the consequences of failing to comply with it have the same penalties, which go up to $2.1 million.
Yes.
And that's, I think, a figure that should draw everyone's attention. And we also, obviously, we've got Symposium coming up. There are some cyber security issues there. They don't deal specifically with the data breach regime, but obviously we will be there. If people want to walk up and have a chat to us about this, that's fine. But definitely keep your eye out for that article, because it's going to go into the most detail that we've got at the moment.
Yes, okay. And the website, the Ethics Centre website, also has a cybersecurity page, which does contain links to a wide variety of high-quality preventative information as well. Obviously, every firm needs to assess its own risk, assess its own practices, and assess its own best response to that. But for most people, I think minimum effort can save 80% of the potential problems. So it's an area where you don't have to throw your hands up in despair. A small amount of effort can have a large return. Yep. That brings us through to pretty much what I think we need to deal with today. Do you have any final comment, Shane?
Yeah, look, just the OIC has set up a website to deal with this, and they do have some guidance around staff procedures on the basis of information management. Everyone should already have something around that, and this is a great opportunity to revisit your staff procedures and look at how information is managed within your office and how you deal with those electronic devices, because, as we've said, prevention is better than cure. You really do want to avoid getting messed up in this.
Okay. And probably the last point I'd want to make is that, of course, this regime applies to clients as much to law firms. So the damage to the reputation or the relationship between you and the client is going to be compounded enormously if you've lost not only the client's confidential data, but their customers' confidential data as well, because they're going to have to go through this same very public and very painful process. So there's a lot of liability exposure, but there's also the significant risk of relationships that you've spent 10 years building simply evaporating overnight with a very simple mistake. Thank you very much for your time today, and I'm hoping that this is the first of a very long line of Ethics Centre Facebook Live presentations. Thank you.
Thank you.